How many deeds do you know when it comes to property transactions? It may interest you to know that aside the deed of assignment, deed of sublease, deed of lease, deed of subdivision, which are the popular ones, and deed of gift, that you know that there is more to the deed in real estate transactions. Stay to the end of this video, watch and learn, and I'll be telling you other deeds that have to do with real estate that can help you when you have this knowledge. My name is Roy, and I am that realtor that takes away the headaches of real estate transactions for you. I make real estate transactions easy for you. Now, let's dive right in. Now, let's start from the very beginning, the very scratch. What is a deed? Now, a deed is simply a document that legally transfers ownership of anything from one person to another. Now, it can be used for properties, can be used for land and all of that. But what you should know first of all is a deed is a document that transfers ownership, right? And today, before I dive into the popular ones, the one that everybody knows about and what you should look out for in this document, I will just touch other deeds that you need to know about as well when it comes to real estate transactions, so that you would know what it means, what exactly you're signing, what exactly you're saying yes to when you sign a particular or receive a particular deed. I'll be starting from unknown to known. So let's start with number one, the deed of mortgage. Now, a deed of mortgage is a deed that is signed by two parties, the lender and the borrower. When a deed of mortgage is signed, it is held by the lender in place till the borrower fulfills or gives back the loan that was borrowed. It's like saying, okay, I want to borrow some money from a bank or a lender, and then I want to use my property as a collateral, okay, to get the money. A deed of mortgage is created where I sign, and then the mortgagee and the mortgagor, I like how that sounds, we both sign, and the person lending to me holds on to that deed of mortgage for the period of time that I will have the money collected from him. So the lender keeps the mortgage as a security from the borrower. If for some reason things go out, it goes south, and the person who came to borrow money can't pay back, is the deed of mortgage. They can use it as proof of, see, he was given to me for security and I can actually sell off and get back my money and all of that. That's how it works. Number two, deed of release. As the name is, so it is that is a deed of release. A deed of release is what the borrower gets when he pays back the loan. After the period of time I've been able to pay back the loan that I borrowed from the lender, the bank, or whoever in this case, a deed of release is given to me saying I have clearly paid back the monies that I collected, and the deed of release frees me from the hands of the lender and hands me back full ownership of my property. And this, of course, is after I have paid up the debt that I got from the mortgage, that I got from the mortgagor as a mortgagee. Okay? Number three, deed of rectification. The deed of rectification is basically used, as the name implies, to rectify, to correct omissions and mistakes that were previously discovered in a title document. All right, it's just to say these are mistakes, please correct and rectify them. A deed of rectification is used when mistakes are realized or seen in title documents, and of course it must be signed and agreed by the parties involved. Number four, deed of partition. Now, the deed of partition, as the name implies, deed of partition is issued when myself, for instance, and you, we have a property together and we want to divide it. We want to partition it. The deed of partition is issued to both of us. So we involve a surveyor who rightly divides the land into two separate plots or sizes so that we both can have our separate plots, right? Especially if it's maybe in cases where we both buy a plot together and we want to separate it, divide it and all of that. A deed of partition is often used in that case. Okay, it's also important to know that, like I said, it's when people co-own a property together. If it's co-owned and you want to divide it and this person gets theirs, this person gets theirs, I get mine, you get yours, then that is when the deed of partition comes into play. The next to it that sounds like it is also a deed of subdivision. This one is mostly used by joint ventures. Let's say 5 of us, 10 of us, 16 of us come together to acquire 15, 28, 30 hectares of land, and we want to have our individual plots separated to us. A deed of subdivision is used where each person who each member of that joint venture wants their parts divided. The deed of subdivision is used to separate a larger piece of land into smaller portions for the diverse or different owners of that particular property. That is where a deed of subdivision comes into action, comes into use. It's mostly used more by developers when developers come together to buy a large plot of land, a large piece of land, and eventually they want to separate their plots for their different stuff, different estate companies and all of that. Deed of subdivision comes into play, and you're going to hear a lot about this in places like Abuja. If you've watched thus far, please don't forget to subscribe to my channel and also hit the notification bell so you get notified each time that I post a video. Now, moving on, we are getting closer to the kinds of deeds that we know. Before we get to the very familiar ones, have you heard of a deed of surrender? Now, a deed of surrender is a deed that is used to relinquish ownership before the agreed time or the end of lease of a property. Let me break it down, the English. Let me make it very simple. I am the landlord. You are the tenant. I leased out my property to you to use for a period of, say, 15 years. And on the 10th year, all right, on the 10th year, you no longer want to continue to use the property for some reason. Probably you want to relocate, you live in the country, and whatever the situation or case may be, you no longer want to abide by the lease. You want to hand back the property land to the landlord. A deed of surrender is used to do that. And of course, if the landlord is willing, if the agreement favors him as well, if you're not asking for, I paid this amount for this amount, now that I'm going back, you know what, give me this, all of that. If the agreement is favorable or pleasing to the landlord as well, the deed of surrender is what is used to say, you know what, we agreed for 15 years, but I know it's not yet 15 years. I want to relinquish, give you back your land on the 10th year. The deed of surrender is used to do that. Now we're getting closer. Next is deed of gift. You know what I'm saying next because I can't remember the number that I called last. But anyway, let's continue. A deed of gift is used to transfer ownership from one person to the other, clearly stating that no monies were paid for this, that it was a gift, it was given. I want to gift you a hectare of land in Asokoro. Hallelujah. I want to gift you a hectare of land in Asokoro. A deed of gift is what I would use to do that. It's clearly stated that I'm handing over this property, this land to you purely by gifting. You didn't have to pay nothing for it. Deed of gift, it's often used in transferring of inheritances and families and all of that. A deed of gift. Now we're getting closer to the ones that we know very well. A deed of sublease. How does a deed of sublease work? What is a deed of sublease all about? A deed of sublease involves three parties. A deed of sublease is used when a tenant wants to lease out a property that he got from the landlord to someone else to use for a period of time, an agreed period of time, depending on the number of years that the lessor got from the landlord. He can lease out some of that to another person who is the lessee. Calm down, Roy. Let's bring it down. Landlord, tenant, lessee. In the sublease, the land is leased to me for a period of, let me use the same 15 years, and in that 15 years I want to lease out 10 years to someone else to use. A deed of sublease is issued from me to the person I am leasing to. Because why? Because the land is not directly mine. I'm not the landlord. I'm leasing the land to a third party, right? So I am subleasing my lease to the next person, right? That is the simplest way I can explain this to you. It is also important to note that in the transaction, that in the deed of sublease, it is actually still subject to the original agreement between the landlord and whoever is leasing you the property, all right? It still has to follow whatever that was agreed between the landlord and the person now leasing to you. It could be a part of a property that he already got from someone else, the landlord, or it could be all of the property he's subleasing to you for a period of time. It's important that you know that a deed of lease is a legal document used to give temporary ownership to the lessee for an agreed period of time, usually from 10 years to 99 years, all right, while the original ownership remains with the landlord. What that means is when you see a deed of lease, it means I'm giving you full rights to my land for a period of 90 years, 10 years, whatever. In that period, you use it as though it's yours, but after 90 years, it returns to me. If you've watched those far, please subscribe to my channel, like this video and share with people so that they can get enlightened and transact rightly in real estate and property acquisition so that they don't get swindled, scammed and all of that. Now finally, the deed of assignment, which is the popular one most people know in Nigeria and most especially in the southeast. Now, the deed of assignment is a legal document that transfers ownership and the rights over a piece of property of land from one person to another. In the deed of assignment, it gives full ownership. It gives full ownership. There's no lease. There's no. It says, I'm giving all my rights over this portion of land to you. I no longer have any right over the land. It is not, I'm not holding on to, you're not holding on to it for a period of time. It is yours forever, as long as you keep renewing your certificate of occupancy or your ground rent on that property. But it simply says, deed of assignment says, I have assigned this property totally to you. My hands are off the property entirely. It is now yours. The deed of assignment conveys all the right that I have over a piece of property over to you. Complete transfer from A to B. That's what the deed of assignment does. Now, of course, you should know that with the deed of assignment, after you get your deed of assignment, it's important that you register it with the land registry so that the transfer of ownership will be recorded and be with the state land registry of the state that you are in. A deed of assignment that is not registered is still not very valid. For instance, I'll tell you why. Let's say we transact and I give you a deed of assignment, right? I've given you total ownership. It's recognizable by law that I've transferred the ownership of that land to you while it is recognizable by law. But if I registered that land with the land registry and issued you a deed of assignment, and even after we transacted that, you did not go to register the deed of assignment you got from me with the land registry, and then for some reason I die and you die and I have kids and you have kids, and it comes up in court and they begin to make research and find out, and they go to the land registry and it's my name that is still registered on that piece of property that was handed over to you, it can cause or lengthen the period of time they both will stay in court. I just had to be very real with you. You need to know that after you get your deed of assignment, it's important that you also go and register it with the land registry of the state that you're operating in or you bought the land from. Okay, now these are the things you should look out for on a deed of assignment. One, look out for the full details of the buyer and the seller, the land description with the survey info, the amount paid, which is the consideration, the date of transaction, the signatures of both parties, and 2 witnesses, ideally with their addresses and IDs. It's important. You should see these on a deed of assignment. It's also part of the deed of assignment that is important, which is the reciter. You should look out for that part. It shows you how the land has come from one person to another, how it is transferred from this person to this person to this person to me and eventually to you. In the case, it lets you know the origin of the property or the land that you are buying. It's important that you look out for these things in a deed of assignment. Now I'll tell you some common mistakes that people make when they want to make when they are getting their deeds, and I want that you avoid this as well. Number one is oftentimes because you're probably book smart or you're knowledgeable to an extent, you feel that you should understand everything in the deed. So I'd say to you that the language in the deed of assignment is not very layman-like. If you're not really a lawyer or don't really understand this, you may say yes or agree to certain things that you're not sure. In cases where you're not very sure, employ the services of a lawyer so that these things will be explained to you. For instance, in some deeds, you can, if you're not sure of certain things, there's a chance that your land will be revoked after a period of time if there's no development on the land. But if you overlook such things or you don't understand it, after 2 years they start saying, oh, according to the deed you agreed to this, and you start speaking English. At that time, English cannot save you because you have signed and agreed. It's important that you, if you don't have full understanding of the deed, that you employ the services of a realtor that understands this, or a lawyer, so that you know what you are signing to. Please do not fall into the category of people who would think that they really can go through it alone, and then at the end of the day, a lot of English is going up and down. It's important that you actually employ the services of a lawyer if need be. That is the much on the deed Of course, and the deed of assignment is where I've talked about the different deeds, and finally the deed of assignment. If there's any new knowledge on the deeds that I do not know about, I did not mention in this video, please feel free to drop it in the comment section. I'd love to know as well. And if there's any further questions you have about the deed or the deed of assignment, please let me know. I'll be very happy to answer those questions for you. Again, you watched us far, you've not subscribed. Come on, how far now? Subscribe to this channel, and I'll see you in the next video. I really felt like a university lecturer on this video. I hope I didn't sound so much like teachy and all of that. Thank you for watching this video thus far, and also please do not forget, if you ever want to transact real estate in the city, if you ever want to transact real estate right here in Nigeria, land and houses, especially in Abuja and Enugu, let me be your guy. Call the phone number on your screen if you ever need to do that. Next video I'll be bringing your way will be about the governor's consent, and the deed of assignment is one document that helps you be able to get that. I will see you in the next video.